regarding immigration. Regardless, since 1982, regardless of whether or not you have employees, or whether your employee, well, not whether or not you have employees, but whether or not your employees are U.S. citizens, foreign nationals, have visas, any status, immigration status, you as employers are required to comply with immigration compliance rules, what we call the employment eligibility verification rules. This, as I mentioned, was started in 1982. That was the first time that employers had this requirement under the Immigration Reform and Control Act. And so it really charged businesses with being sort of the police of making sure that the employees that you have are authorized to be in the United States. And in some cases, they may be authorized to be in the United States, but they may not be authorized to work. You can have foreign nationals who come here as visitors, who come here as students, who come here for multiple purposes legally. But if their authorization to be here does not include work eligibility, then they would not be authorized to work for you. So, as I mentioned, the government has charged employers with doing this, and despite the fact that it's been about 30-some years that this law has been in place, there's still employers who get in trouble with the rules. Either they're on one side of not complying in terms of finding out whether, or crossing the T's and dotting the I's with respect to determining whether the employees have employment eligibility, or they go overboard and actually require more than necessary. So we're going to talk about towing that fine line in terms of making sure that you do comply with finding out whether your employees are employment eligible, but you don't want to go too far and discriminate against them. So I'm going to talk about just who's involved with immigration compliance with respect to employers. There are two agencies that employers really need to be aware of. First, the U.S. Immigration and Customs Enforcement, or what we call ICE. Many of you have heard of ICE before. You've heard the term ICE. This is an agency that's part of the Department of Homeland Security, and they're really what we call the immigration police. They're responsible for making sure that employers are complying with our I-9 rules, the I-9 form rules, which we'll talk a little bit more about later. And they're also responsible for charging those who are not here legally in the United States, whether they came without legal status or whether they lost their legal status or whether they're actually working without authorization, for example, in violation of their legal status. They are charged with placing them or removing them from the United States. The website here, ice.gov, a lot of information for employers, so you can really get a lot of good information there if you have questions about your responsibilities as employers. The other agency really is charged with the other side that I talked about in terms of ensuring that you as an employer are not discriminating against those who have legal status here, have work authorization, but they're subject or being have issues of employment discrimination. This is the OSC, Office of Special Counsel. It is part of the U.S. Department of Justice, and that is where employers can get good information about what their responsibilities are, what the requirements are with respect to avoiding unfair employment practices, but it's also where employees who feel that they've been discriminated against can file a charge. So this is one of the charging agencies, in addition to the EEOC, which is another one that can cover some of these issues as well. So just to give you a kind of idea of what we're seeing out there in terms of cases and the kinds of things that employers can get in trouble for, there's one recent case from PM Packing, a packaging company, had about 100 employees, and they ended up getting an I-9 audit, which what we mean is that ICE came in, wanted to find out whether they were complying, reviewed their I-9s, and determined that there were about, at least 22 violations where the company altogether just did not have I-9s for those employees. Those employees were legally here, they did have work authorization, however, they never completed an I-9. So that's a violation in itself, just by the fact that they did not complete that I-9. And that's what we call a substantive violation. There's just really no getting around that. They're not going to not fine you for something like that. You are going to get fined if you have a substantive violation. They also had about 50 other violations as well. So they ended up basically being sanctioned for that. The ICE initially charged them $53,000. But they had, of course, that's a lot of money. They wanted to contest that, so they spent the attorney's fees to go to the court, which basically ended up reducing the fines. But of course, even if it was cut in half, they still had to pay fines and fees and attorney's fees to get to that point. So that's the point there, is that if they had a system, the checks and balances, which apparently they didn't have, to determine, to make sure that we are completing I-9 forms for every single one of our employees. And we have a system of verifying that. We have oversight over that. We check that periodically so that we don't get into this situation where we end up being audited and we don't have our ducks in a row. Another company recently, Gulf International, they also went through the process of contesting the findings in their, for their I-9 audit. They ended up getting charged with $136,000 of fines. Because they basically repeated the same mistake over and over again, which is something that typically happens, because once you start to do things wrong, if you don't check those things, or you don't have a way of verifying that you are properly trained in doing these things, you end up continuing that same mistake. So in this situation, the employer did complete I-9s for each employee, but for 110 of those employees, the employer did not sign Section 2, and that's what we call, again, a substantive violation. Employers must sign Section 2, which says, I have verified the employee's employment eligibility. I've done my part. They completed all the other information, but they did not sign. And because they didn't sign, they were found to be in violation and fined as well. Again, they went through the process of contesting the ICE determination, went through the system and court system, and ended up getting that fine pretty much cut in half. However, again, they still had to spend time and fees to get through that stage. One interesting point about both of these cases is that they did use the EVerify system. How many of you have heard of EVerify system? Okay, that's an electronic system to verify employment eligibility. It's voluntary in most cases. Employers don't have to be a part of it. A lot of employers do become a part of it. It gives some comfort level in terms of, you know, security and knowing that the employee is at least showing up as employment eligible. However, it does not relieve the employer of properly completing I-9 forms. And so having that security does not relieve you of those obligations. And in fact, even with EVerify, there's always compliance actions taking place. And what I mean by that is ICE is monitoring those who are using EVerify. For example, in 2014, ICE conducted about 86,000 compliance activities, which means that they called or they talked to employers. They just wanted to see how you were doing. They checked to make sure that they were compliant with the EVerify process. And if there are violations of that, they can also decide to go into or decide to audit your records as well. So it's important to not feel a comfort level that if I EVerify, I don't have, you know, the other obligations as well. The last case that I'll mention briefly talks again about the other side, again, of I-9 or immigration compliance, which is anti-discrimination laws. As I mentioned before, the Office of Special Counsel is the agency charged with any complaints of employment discrimination based on immigration status. Employers, large employers, small employers alike, and these cases here are really kind of fairly large employers where they, again, went too far in their zealousness to make sure that they were, you know, having an eligible workforce. They ended up requiring certain documents from certain employers. So the rule is generally that if you are verifying employment eligibility of an employee, they have the option of producing any qualified documents that are on the I-9 form. You cannot ask them for a specific document. Where employers are still getting into trouble is if they see that someone's a permanent resident, not a US citizen, for example, they are asking to see the green card. Even if they're not giving that employee the option of, well, I have my Social Security card, I have my driver's license, I have maybe another document that shows my employment eligibility that's compliant with the I-9. Despite showing those documents, the employer is asking for the green card, and that is specifically a violation. These are the instances here where employers were consistently asking for green cards or certain documents in order to prove employment eligibility rather than letting the employee provide that information. As you can see, the fines range pretty high. A yellow cab paid almost $500,000 in fines. Abercrombie paid $156,000 in back pay. So it's really important to be careful. inquiries all the time from permanent residents who, for example, their green card expires. And the employer wants to make sure that they have employment eligibility, so they ask the employee to provide the green card. Well, that is probably the biggest no-no out there for employers. Someone who has permanent residence does not have, the permanent residence does not expire, despite the fact that the card might expire. That's just their proof of permanent residence. Expiration of the card itself does not eliminate their permanent residence. They have to go through a lot more for that to happen. So employers are really prohibited from re-verifying employment eligibility based on the expiration of a green card. If you have someone who's a permanent resident, they've provided the information to prove they're work eligible, you do not need to re-verify their work eligibility just because their green card expired. So it's very important to keep that in mind. In your workbook, there are questions about, or this is just to follow on the outline, why are written immigration compliance procedures necessary? And this is what we're going to talk more about today. Ms. Lopez will just come up in a minute and give you some more details. To avoid those kinds of issues where you're missing I-9s or you're not properly completing them or you're going overboard, you really need to have an immigration compliance plan in place with your company if you have employees. So what are the reasons for that? Well, first of all, you want clear direction and consistency and to show a culture of compliance. As Brian's mentioned, employee handbooks are the same thing. You need to have those rules, and you need to have an understanding of those who are charged with this responsibility, that they really know what they need to do and that they're properly trained in doing that. Secondly, it really signals to the government that you're serious about this issue, that you're serious about compliance. ICE considers this one of the best practices for any employer to have an immigration compliance written plan that explains how they will deal with immigration related issues. And we'll talk again further about what you need to have in that plan. But ICE considers that best practice. So if you are audited and you end up maybe missing a few things and having some mistakes in your I-9 forms, for example, they will consider the fact that you have an immigration compliance plan to consider, I won't say they will not fine you, but they can consider the amount of the fine. The fines range anywhere from $110 to $1,100 per violation. So they can go in that lower end if they feel like you really are trying to comply. So it's important to have the written compliance plan for that. And then the fine, that kind of goes into the third reason, it really reduces the risk of your violations because you have a plan, you have processes, you have proper training, you have those things that will keep your process compliant. So with that, I'm going to let Ms. Lopez talk more about the actual requirements. You got a question? Okay. Mm-hmm.
Thank you, Ann. Well, after you heard all those great news from Ann, so I'm going to just give you some good news that you can protect yourselves. Audits by the Department of Immigration or the Department of Labor are not a matter of if, but when, because they're happening and they're doing them more and more frequently. One of the things that I always kind of mention in these kind of presentations is that we are constantly surprised, and it takes us every time by surprise when we learn that many employers, they don't believe they're subject to the I-9 immigration compliance because they don't hire immigrants or foreign workers. Well, the I-9, which is this little form, and I'm pretty sure everybody in this room knows, applies to every employer, every employee in the United States, whether a U.S. citizen or not U.S. citizen. If you have an employee, then that employee has to complete this form when they are going to start to work. The first day, and the rules are pretty clear on this, the form has to start, the employee has to start completing the form on the first date of employment, and it has to be completed by the third day. Not doing or not complying with this 3 days rule is a substantive violation. And Ann already told you the fines and all the things that come along with not completing with the forms within the time. So everybody. So if anybody says, no, I don't employ immigrants, it doesn't matter. if you have an employee, you have to have one of these forms completed. When the 3 days rule, if you do EVerify, then you also have to do the EVerify part of this process within those 3 days. So you have the case where an employee is a foreign worker, he comes into the United States, or a recently admitted legal permanent resident, and they are still in the process of obtaining a Social Security number. Well, the lack of having or not having a Social Security number doesn't prevent that employee from working. They can still work, they can still complete this form, and you have to give them enough time to get the Social Security and give it to you. That means that because if you don't have the Social Security number, and you have to do, oh, I haven't moved this thing, and you have to do the EVerify process. To do the EVerify, which is a different process from the I-9, and Ann mentioned, if you do EVerify, it doesn't exclude you from doing the I-9. You still have to do the I-9. There's nothing that will exclude you from doing an I-9. But if you do EVerify and you don't have a Social Security number, then you can complete the EVerify process. One thing that is going to happen is when you are documenting the lack of having a Social Security number, you have to make a notation in this form that you're not completing the EVerify process within those 3 days, because if you participate in the program, you have to do it. You're not completing it within those 3 days because you're waiting for the Social Security number. And then when you get that Social Security number, then you can complete the EVerify, which it will bring to the attention of the government that you are kind of late completing the EVerify because you're supposed to do it within 3 days. And then, but as long as you have in your records that it was because of the Social Security delay, then you're okay. So that's going to cover your liability. You're going to be protected there. The EVerify system is, as Ann mentioned, is an internet-based system. It's run by the government. It only verifies employment. And if you use it, in Texas, it's not mandatory yet. There's other states, people have no choice. But if you have a company in Texas and the company has a branch in, let's say, Arizona, where EVerify is mandatory, then you're going to have to do EVerify for all your companies, regardless of the state that you are located. Anti-discrimination policies, this form, when you're completing this form that has 3 parts, the first part is completed by the employee, the second part is completed by the employer, and the third part is more about re-verification. Like Ann was mentioning, if you have a document that shows eligibility to work is going to expire, you need to re-verify that the person obtained a new document that will allow him, her to continue to work. So when we're looking at anti-discrimination, what you are not supposed to do is to request specific forms. You need to give your employees the copy of this form that on the back or on a separate paper, it lists 3 columns, A, B, and C. And the employee, according to the information they complete on the front, they choose the documents they're going to give you. If you start being selective as to the kind of documents that you are requiring, that can be construed as discrimination. So you need to be careful and let them complete it, let them produce what they need to. Just make sure that whatever they put on this form matches whatever they're producing in terms of documents. Training and supervision. Usually in many companies, you have a person that is designated to do the I-9 process, the HR or the manager. And these are the people who receive the employee on the first day and give them the rules and information about the company and have them complete this form. We do recommend people to train the person or the team or the department or the HR or whoever is in charge of doing this form to do it uniformly and consistently. There are many rules, and one of the, I think that is very deceiving when we are giving information out to call it immigration compliance, because it's really not just immigration. There's a set of rules. yes, it's based on immigration regulation, but also it affects many other things in your company, like employment compliance. So you need to be careful about who is doing these forms and how. You are the employer. If you're the owner of the company, they will look at you when they are looking at errors or mistakes made on this form. How well the employee is trained, it depends on how well you manage your company. Secure record keeping, the I-9 forms, we always recommend people to have a little folder where they keep all the I-9 forms for all employees. Usually, the best practice is to keep it separate from the personnel files. If you keep the I-9 compliance or the I-9 form for an employee in his personal or her personal file, if DOL, ICE, or one of these agencies come to your place of work to audit your records and you open that personal file, then you are giving them access to all the records in that personal file. And you don't want to do that. You just want to give them what they need, your I-9. So the best practice is to keep it in a separate file, separate cabinet, accessible, easy to find when you need to, where you can have like a tickler system. If you have employees that work authorization might expire, you might want to follow up on those and make sure you verify they still have authorization to work. If you have different branches, different offices, centralized, where the I-9s are kept and who is responsible for completing the forms. If you have several managers, several locations, make sure you do training for everybody, because I-9 should be a company policy, something that is uniform and centralized. Retention. The rule is you go by the date of hire plus 3 years, or date of separation plus 1 year, whichever date is later. So if you hire an employee, let's say January 1st, 2010, and the employee, and then you plus 3, you're supposed to keep the form for 3 years, January 1st, 2013. As long as the employee is with you, the form must be in your records at all times during employment, okay? When you count the 3 and 1 years is at the time of separation. If the person, as I mentioned, is with you for longer than 3 years, then more likely you're gonna do day or higher plus 1 year. But if the person is only with you 2 months, then you more likely are gonna have to do the date of hire plus 3 years, whichever is later. So one other recommendation we make to people, and is good when you have those I-9 forms in a separate file, is also keep the I-9 forms that you know that you have a retention obligation for a certain period of time. Once that time is up, get rid of it. Because if you are audited and those forms that you could have gotten rid of, they're still there, and the Department of Immigration or the Labor or any of these agencies come and take a look at those forms and they have violations, they're also going to penalize you for the forms that are expired. So clean your records when you have a chance. Anti-discrimination, I kind of mentioned what they look for, what they're holding employers accountable to. The re-verification, and mentioned you do not have to re-verify green cards. I have my green card, it's permanent. It will, even if it has an expiration date, the green card, my status as a green card holder never expires, so you do not have to re-verify that. Employment authorization, you do, because those usually have an expiration date. And be careful when you are asking for documentation to re-verify employment, because depending as to the person's status in the United States, they might produce certain documents that you might not be familiar with, but those documents allows them to work in the United States. So if in case of doubt, there's always attorneys, good attorneys like us, and also the employment agencies, Texas Work Commission, the Department of Immigration, they have tons of information about these. Make sure you're following the rules. Consistency, credibility, report, enforce. Once you train your person in charge of doing the I-9 forms, be consistent in enforcing what you say needs to be done with the forms, and how, and when, and the terms, and who is doing it, and how they're kept. One of the things that the Department of Labor or ICE, they look at, and we see these over and over, is good faith. What good faith means, you employer did everything you can. If you found a mistake on the form, you try to fix it, how you try to do it. That it doesn't mean they're not gonna find you. It means that they might reduce the fine. And when you're counting hundreds and thousands, mitigation factors are always to keep it in the forefront. Okay. Self-audit, this is a best practice. We can't recommend enough employers to audit your own I-9s. It's good if you hire an attorney, there's confidentiality, to come to your place and do a little audit. If you have a lot of I-9s, take a few samples, see what, because the mistakes you find and a few more than likely are happening in all the other forms. Or you can hire a third person to do the audits. Not necessarily an attorney, but there's not gonna be confidentiality. Go take a look at your I-9s. And if you find mistakes, what can you do? You can fix it. And there's rules on how you can fix the I-9s. Follow them. Don't get rid of the forms that you fix, but do it according to the rules, because if you are audited, they're gonna be looking at how you try to fix the problem. And good faith is key when it comes to these kind of compliance issues. Conduct training, corrections. After you do the training, and this is what you can do once you did your audit and you found out a few mistakes and then you want to get them corrected, do training. Follow up on the mistakes were corrected, then review the audit report and make sure if you have one I-9, review it. Make sure it's correctly done. If you have 10, if you have more, you need to be sure you comply with this little form. It's one page, but it's kind of dangerous, so pay attention to that one. Now I'm gonna leave you with Ann, who's gonna talk to you about enforcement.
Oh. Tag with this. Okay. So as part of the immigration compliance plan that you implement in your office, you need to also include what or how you will respond, or training and how you will respond if you are actually audited by the government. As we mentioned, ICE is the agency that typically audits employers to determine whether or not they've complied with the I-9 requirements. And so this is sort of the process that you find with the ICE enforcement action, as we call it, where you receive what's called a notice of inspection, usually by mail, that tells you we're going to inspect your I-9s. We want to see them within 3 days, 3 business days. That usually isn't the time to figure out whether you're compliant with it. If you had a process in place, you should feel pretty confident that your I-9s are meeting those requirements. So this, I won't go, we don't have the time to go through all of the whole graph here, but this kind of lays out exactly what could happen, and if you are fined or you are found to have violations, the process you can go through to contest it or either pay the fine would always be the option as well, just depending on how much it is. But let's say you are audited. What's really important is to have someone who does understand that this could happen and who is really ready for this if it does happen. So choose a point person, choose someone who will be responsible if that person leaves. Make sure you hire and train someone who can also take that place. Usually you will be, if you actually get ICE to come onto your site without that notice of inspection, where what we typically call that is a raid, then you want to ask to see the authorization for their search. You can ask for their warrant. You want to make a copy of any documents that you receive from the government so that you have that to pretty much address with your attorney. Okay. You can ask them about the purpose and scope of the inspection and make sure that you comply with the warrant, but don't volunteer more than the warrant requires. You're not required to give them your whole business and open it up for them to look at anything and everything that you have. Stay within the terms of the warrant. And you can accompany the agents on the search. So you don't have to allow them to randomly go through your offices. If it's something where you're talking about I-9 inspection, as I mentioned before, you typically get 3 days notice, sometimes more, but they give you 3 days notice. You can ask for an extension if you need it. You should already have this done, but if you don't have your I-9 separate from your personnel records, then do so. Don't give your whole personnel record to the government. They're only charged with looking at that I-9. So you want to make sure that you separate those out if they aren't already separated. You can have an off-site review if they're asking for you to provide the documents to them. They don't want to come on site, or you don't want them to come on site. You can offer them copies of the documents or just comply with that, but you have to make sure that you keep copies for yourself. Make sure you have those. An on-site review, if they're coming on site to do the review of your I-9s, don't mingle them with the employees. Make sure you have them in a separate room, a conference room somewhere where it's private and separate from your work areas, because you just don't need to have your employees involved in that. See, I got 1 minute and I can do that, okay? Okay. But most of all, as we have to say, you need to call an experienced attorney immediately. Whenever you receive any notice from the government where they're asking to inspect your records, you need to call an experienced attorney to help walk you through that process. We've seen a lot of the same situations, and we can advise you with that. Ideally, you want to be sure that you already have an attorney that's familiar with your I-9 process, because if you're calling someone who isn't familiar with that, they're starting from the beginning. They have to do a lot more in terms of being able to represent you quickly. If you want them to be able to represent you quickly, they're familiar with that, with your business, familiar with your I-9s. They've already helped you to audit, do a self-audit. Then you can feel pretty comfortable that they can pretty much take over and represent you before the government. So it's really important, really ideally for you to have somebody already on board that you can contact if you do get into a situation where you are inspected by the government. So that kind of concludes our presentation with respect to immigration reform, or immigration reform. We're not talking about immigration reform. We'll talk about it a different day, okay? But immigration compliance. The last mistake that we want you to know about that employers make was really a mistake of not being proactive. And what we mean by that is not annually conducting a review of your legal processes, how you are complying with the laws. There's a whole, we've already talked about so many different areas here, and you're probably like, oh my goodness, there's so much to think about, and there is. And so you really want to know what's going on in your company so that you're not surprised. You can uncover any of those hidden risks that may be out there. And so that's why we recommend that any business who's doing a business, certainly, conduct what we call a legal checkup, which is kind of like, you go to checkup. It's better to be preventive in your health care than it is to get hospital bills because you weren't preventive. You didn't go to the doctor every year, and all of a sudden, something has progressed to the point where it's much more costly to address. And that's the same thing with legal problems. You may have, there are probably issues in your business, and it's a good idea to look at those legal issues in advance, talk to an attorney to diagnose those issues, determine a plan to eliminate them, to avoid them if possible, so that you're not surprised and you're not thinking, oh my God, what will happen, if this happens to my business and I get into a lawsuit, get into those issues that Bill and Stephen and all of us talked about this today. So in your handout, there is a legal checkup mini review that you can do, kind of survey your business to see if these few areas that we have in that checklist that you are complying with those, or if there are any issues there. Take a look at that. Usually, at the beginning of the year, you kind of look at what you need to do to manage your business properly. I'm not saying at the beginning you do that all the time, I'm sure, okay? But the beginning of the year is something that's a good idea to do. So we recommend that you take a look at that checklist, go through that. If there are any issues, address them with your attorneys. And also keep in mind that we will also offer additional workshops in next year that we can really hone in on those issues. So if you indicate that you would like that information about those additional workshops that are coming up, please let us know. You will just fill out the evaluation forms and indicate that you do want additional information, and we will certainly get back with you and make sure that you get notices of what we will have in the future. And those workshops will be a lot smaller, because we want to be able to individually work with you. So if that's something that you feel will be of value to you, then please be sure to sign up for those as we send them out to you. We do have time for questions. If you have any questions for any of us, if you